we are back. We've procured the services of Ross Truckee for 2 sentences here this morning on a Wednesday. Abigail Stoll is with us from the prosecutor's office. We have one matter set at 10:30 and one set at 11. So we're going to get right to our work. Where we are doing, what we're working on is People versus Caleb Brian Stainer. There are 2 files, 252330 SM and 252434 FY. As I indicated, Ross Truckee is here with the defendant and Abigail Stoll. The defendant entered a plea which resolved both of these cases. On November the 14th, he was charged with domestic violence and malicious destruction of personal property. The complaining witness in that case was Maria Baldridge. Miss Baldridge and Mr. Stainer have 2 small children together. The defendant spent 4 days in jail on that case before posting a bond.
This case starts like many domestic violence hearings do. Quiet, procedural, almost routine, but the details quickly tell a very different story. We're dealing with Caleb Brian Stainer, a 26-year-old father of 2, standing before the court with 2 separate files tied to one escalating pattern of behavior. What begins as a domestic dispute turns into bond violations, illegal entry, alcohol abuse, and serious safety concerns for both the victim and the children involved. The judge immediately signals that this is not just about punishment, it's about control, accountability, and risk. Multiple jail stays, a plea agreement that dismissed felony charges, and a victim who has not provided input all complicate the court's job. Add alcohol into the mix, and the stakes rise even higher. The real question hanging over this hearing is simple but heavy. Is this someone ready to change, or someone one bad decision away from something far worse? Stay locked in, because the court is about to answer that.
Bond was posted on November 17th. The defendant was arrested on, November 17th. He was arrested on the 13th. Then, a few days later, on November 26th, the defendant was charged with home invasion, 2nd degree, illegal entry, aggravated stalking, and interfering with a crime report. As part of a joint, in that case, he spent 10 days in jail. He was in jail from November 26th to December 6th. And then he posted a very large surety bond. Pursuant to the plea agreement, defendant pled guilty to malicious destruction of personal property less than 100 in file 252330 and to domestic violence and illegal entry in file 252434 FY. All the other charges were resolved. The felony charges were dismissed. As I would usually do in such a case, I continued the matter to get more information and get input from the victim. So we've set the matter for today. I didn't get any victim input. According to Ms. Stoll, the prosecutor hasn't had any additional input from the complaining witness. And we're ready to do sentencing in these 2 matters. Mr. Truckee, what would you like me to know?
Thank you, Your Honor. Mr. Stainer, Mr. Stainer is 26 years old. employed full-time at Bill's in Bronson. He's from that area. He's residing in that area with his father now since these instances.
Which is where?
Bronson.
Okay.
My father's house or my
Yeah, your father's house.
It's in Baroque.
Baroque,
Yeah.
okay. I know where Bill's is. I haven't been there a long time, but what do you do there?
I am one of the more common broil cooks. I usually work on the broiler. So I
Make lots of
I
steaks?
do, I mean, hundreds, maybe if not 1,000 a week.
All right.
So he's working there in that environment. He's got a 5-month-old and a 23-month-old, both of whom are sons in common with the complainant here. Complainant's 22 years old. It appears to me as an outside person that these are two relatively young people with two very young children and too much alcohol in their house. Both of these had alcohol as a component. Mr. Stainer recognizes that had alcohol not been involved, likely these would have resolved in a different way other than a shouting match, screaming match, domestic violence conviction, and everything else. Mr. Stainer was exposed to domestic violence as a child, and I believe he's now cognizant that that affects how he responds when presented with intermarital conflict. And that's something that he would be working on to resolve. As well, the alcohol thing. He's got here with him a few chips that he's earned since his second arrest.
What are they? 30-day, 10-day, 30-day?
It's the blue chip is for showing up the first time as the initial, and then I just yesterday at class I got my 30-day chip.
All right, well, that's a good start. People have given some of those to me over the years, my little treasure box. But all right.
He's continued to attend after his release from jail, which is really what counts to me. When you're in the jail, there's not much to do. And so getting out for meetings, fine. But he's maintained that in Bronson. Had a local church since then. And I believe that has helped his overall personhood. So his criminal history is limited. He was charged with an assault and battery with an acquaintance who Your Honor is familiar with. I'll not use his name unless Your Honor wants it, but that was dismissed at a later time in 2022 or thereabouts. Outside of that, there's not a criminal history to speak of. He's been compliant with his tether this entire time. I think that the main thing in this case is we have somebody that's 26, which I'm getting older, but that's on the edge of what I would call young. Okay. And that is definitely the time where put up or shut up in life starts to happen. And this is
tomorrow we'll either do Edge of 17 or 18 by Alice Cooper.
I'd go with the Alice Cooper song,
right.
Judge. I saw him in concert and it's stupendous. But the quote he gave to me was, he never had something kick me in the ass like this, because this is the time where it's like, am I going to live this DV drunk, bad example for the kid's life, or am I going to put it together and be a man? And I am hopeful that Caleb is going to be a man now. And this is the time for that. So I'm asking that the court sentence him to a term of probation designed to continue his sobriety and treatment and help him resolve the issues that led to this incident and help him find what healthy relationships may be and what is okay and what's not okay and how to handle that marital stress. Thank you.
All right, well, who's in the Fawn River Road address right now?
Mariah.
And it's your father's house?
It's not his house. It's okay. So he has a friend from a long time ago. His name's Scott Plank. He lives 2-3 hours away from here. My dad oversees the property.
All right, so he's the property manager for the owner.
Yes, that's right.
All right, and I don't know if I have an estimate of the door jamb got broken, if I have a damage estimate.
I don't know if it matters, but I did put a new flange on the door and I did fix it when I got out of jail.
All right, well, that's relevant to me. Now, you've got two very small children, very close together in age.
Yes.
Does she have help with the kids? Are Are her
I-
parents nearby or your parents or?
Her parents are not. My family does help quite a bit. Her grandparents help out here and there, but my family takes.
So right now she's at home with two very small kids.
Correct.
And at Christmas, you weren't able to have any contact with
No,
each other.
my mom, she did release them to my mom on the 24th for Christmas Eve, and I got to see them for a couple hours. But it's been pretty limited other than that. I had them the week that I was here, the 16th, and then I didn't have them for another week. Then I just had them again for about a week. So it's kind of week on, week off through my parents. They're going and getting them and bringing them to me.
Well, that's the best you can do under the no contact circumstances.
Yes.
Ms. Stoll, Mr. O'Bear and Mr. Truckee spent a lot of time on this, worked out this plea agreement. I'd hope maybe to hear from her, but what's your input here?
Well, Your Honor, the defendant may be young, but he is still old enough to know better than to assault the mother of his children. What especially concerns me is his actions in the felony file. He violated the conditions of his bond, showed back up at the house where she was staying, the victim. According to the police report, she tried to run away from him. She was running across the yard and he dragged her back towards the trailer. And at 26 years old, that's certainly old enough to know better than to treat anyone like that. I do believe probation is appropriate. I would recommend a lengthier term of probation, possibly 24 months, but ultimately I would leave it to the court's discretion.
This is an important moment to pause and clarify what's happening legally. Caleb isn't facing random accusations. He's dealing with two separate criminal files, both resolved through a single plea agreement. That means the court is looking at a timeline of behavior, not an isolated incident. One file involves domestic violence and property damage. The other escalates into illegal entry and stalking-related conduct after bond conditions were already in place. When a judge sees multiple files like this, the focus shifts from what happened once to what pattern is emerging. The fact that felony charges were dismissed doesn't erase the conduct, it reflects negotiation, evidence, and judicial discretion. And when the judge notes the lack of victim input, it creates a vacuum the court must fill carefully. So ask yourself, should a court lean toward leniency when the victim is silent, or toward caution when children are involved? Here, the judge cuts straight to the core issue. Alcohol didn't cause this, but it fueled it. That distinction matters. Courts don't accept intoxication as a shield, they treat it as a warning sign. The judge openly acknowledges that without alcohol, this may have ended as an argument. But once alcohol enters the picture, judgment drops, aggression rises, and consequences multiply. What's striking is the balance the judge maintains. He recognizes Caleb's background, exposure to domestic violence as a child, but refuses to let that become justification. Sobriety chips and meeting attendance are acknowledged. Yet the message is clear. Progress only matters if it continues outside the courtroom. This is where viewers should ask themselves, how much grace should the system give someone who's trying after they've already crossed legal lines?
Now, you didn't move into this house till July of 2026 or 2025.
Yes.
So you had two kids, but you didn't live together?
No, we lived together. We were.
But you lived in a different place.
Yeah, we just came up on the trailer and it was a lot better for the kids. So
Now, depending on which version you believe, she was mad at you because what you were doing on your phone, or you were mad at her for what she was doing on her phone. And as your lawyer said, alcohol was a factor here. I don't know that she ever sent in her victim input stuff. Uh, so you guys are gonna have to figure it out. You got two small children, you didn't get married, so she has paramount parental rights. I don't know what her position is regarding allowing you back into the home. Normally, when I do a probation, I lift the no contact provision. So let's do the malicious destruction of property case first. That's the November 13th case. The domestic violence charge in that case was dismissed. You spent 4 days in jail in that case before you posted the bond. There's a $75 crime victims' rights fee and a $50 state minimum fee and a $55 fine, which equals $180. You posted a $2,000 10% bond. You posted $200. The court keeps 10% of a 10% bond, so there's $180 to apply to your fines and costs. I'll reserve on restitution.
This section shifts the focus away from Caleb and onto the children, where it belongs. Two kids, barely toddlers, caught in the middle of instability, no contact orders, and adult decisions they didn't make. The judge's questions aren't casual. They're investigative. Who's helping with childcare? Who's paying bills? Who's ensuring stability? This is where courtroom reality gets uncomfortable. Legal cases don't happen in a vacuum. When parents are fighting, violating court orders, and abusing substances, the system starts looking toward child welfare. The judge doesn't threaten foster care lightly. He mentions it as a legal outcome he's seen before. That's a wake-up call. So here's the question. At what point does personal conflict become a public responsibility to intervene?
That probably isn't any. You fix the door and your father's the property manager. But if there is, I can always amend the order and allow it. That takes care of the 13th matter. Now, the next one. Ten days later. And obviously the prosecutor was quite concerned about this. There were bond conditions of no contact, which you violated. Who are Jason and Samantha Stainer?
Those are my parents.
All right.
The prosecutor's statement is blunt, and intentionally so. Youth is no longer a mitigating factor when violence escalates after court intervention. The key issue here isn't just the original incident, it's the bond violation. Courts issue no contact orders to prevent further harm. Ignoring that order signals risk. According to police reports, the victim tried to flee. That detail matters. Courts treat attempts to escape as indicators of fear and danger. The prosecutor isn't asking for maximum punishment, she's asking for longer supervision. Probation here isn't mercy, it's monitoring. So the audience should consider, if someone violates bond once, how confident should the court be that they'll follow conditions later?
She stated Caleb was at her house when she got home, that he kept driving by, leaving and coming back. She kept asking Caleb to leave, but he would not do so, at which time she left. When she came back, Caleb was gone, but then he returned when he saw her vehicle back in the driveway. Caleb entered the residence through a front door, which does not lock, and came into her bedroom, grabbed her by the head using both hands and hit the back of her head on the bed frame multiple times. She had bumps on her head. According to Baldridge, Caleb held her down by her arms with her legs and punched her in the face using a closed fist. Baldridge stated that Caleb told her he would beat her ass. He would give her a reason to call the cops. Took the phone from her. I mean, that's bad. She had to run out and call for help. They arrested you like over at Bronson later that night. So there's no mention here about alcohol, except it should be noted for medical reasons. I asked Caleb on a 1 to 10 scale how drunk he was, and he said a 3. Caleb said she was drunk, but I just came from Baldridge and she did not note any signs of intoxication.
This is one of the most damaging moments for the defense. A blood alcohol level of 0.240 isn't debatable. It's measurable, scientific, and extreme. The judge dismantles the defendant's self-assessment with cold facts. What Caleb called a 3 out of 10 doesn't align with medical reality. The judge also highlights something many overlook. Tolerance doesn't make drinking safer, it makes it more dangerous. You don't reach that level without habitual use. Combine that with driving and bond violations, and the court sees compounded risk. This isn't just about breaking rules, it's about endangering lives. So ask yourself honestly, how often do people underestimate their intoxication until the numbers are read aloud in court? This is the hardest decision of the hearing. The judge openly states that 90 days in jail would be justified. But he also recognizes what jail would cost: employment, stability, and any chance at rebuilding. Instead, the court chooses deferred jail time paired with strict probation. That deferred sentence isn't leniency, it's leverage. One violation and the remaining jail time activates. The no-contact order stays in place because the victim hasn't weighed in. That's caution, not cruelty. The court is saying, you're getting one controlled chance, don't waste it. So here's the key question. Is suspended jail time a stronger motivator than immediate incarceration?
Anyway, alcohol was a factor, but you weren't even supposed to be there. She's got a 3-month-old child in the house. She doesn't have time to be out driving around. By the time they finally caught up with you at the jail, your blood alcohol was 240. So this case also includes a bunch of drunk driving, where you're driving around here in Branch County while you're drunk. You got 30 days sober. I guess that's a good start. If you're both drunk, I don't know who's taking care of these very young children. But you don't just get to that high of a blood alcohol level without building up a tolerance. For you, a 2.4 is a 3 on a scale of 1 to 10. I hate to think what you're like when you get to a 10. Of course, when you're drunk, you're not the best judge of how drunk you are. On the illegal entry charge from the second incident, or 10 days credit, 10 days. Concur with the domestic violence case. Zero fine and costs. I had really hoped to hear from her. I'm not sure what she feels about the no contact provision or how she feels about this. She also bit you. I mean, it's just bad. As Ms. Stoll said, you guys are old enough to know better than this.
I have advised my client that through my work in the family courts, this is the kind of situation that leads to foster care.
Yes,
So
it does.
I think that has also been made clear to him.
All right, on the domestic violence charge, what do I do? I don't like the fact that you were on a bond with no alcohol and no contact and no assaultive or threatening behavior. You went out and did exactly the things I told you not to do. And according to her, you punched her in the face. You were 3 times the legal limit to drive a car. Plus you're driving a car around drunk. One option is just give you 90 days in jail and see how you like that. It makes you lose your job. This deserves 90 days or more in jail. We set a very high bond, $30,000 cash or surety, was reduced from a felony to a misdemeanor, and then the bond was reduced accordingly. But I think you posted a $30,000 bond. Did you post a bond through a bonding company?
Yes, sir.
You had to put up $3,000?
1,800.
What's that?
1,800.
And that's all money away from your family.
I just made my first payment on the bond today.
Say that?
I said I have to make my first payment on the bond today.
Prosecutor's asking for 4 months probation. I think that's appropriate. You can be discharged at the end of 12. It's to be determined whether you're eligible for a deferral. I'm going to send you to the DV class, the full class. No drugs and no alcohol, no assaultive behavior, no marijuana. Do you use marijuana?
I do not.
I'm going to sentence you to 90 days in jail. Credit 10. Of the 90 days, 80 are deferred. Won't take much for me to pull the pin and just give you the balance of the jail. So I want you to comply with the terms of this probation.
Yes, sir.
Fines are 0. You got enough to pay. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee. $960 probation oversight fee, which could be cut in half. If you do it in 1 year, you had to pay for the class. The deferral is to be determined. I can't do a deferral.
This case shows how courts balance accountability with opportunity. Kayla Bryan Stainer faced multiple charges tied to domestic violence, alcohol abuse, and bond violations, while 2 very young children remained at the center of concern. The judge imposed probation, deferred jail time, strict sobriety rules, financial penalties, and left the no-contact order in place until the victim chooses otherwise. Nothing here was brushed aside. Every decision was calculated to protect the victim, safeguard the children, and give the defendant a final chance to prove real change. The takeaway is clear: the system can forgive mistakes, but it won't tolerate repeated defiance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns where actions meet consequences.
Domestic violence class without the prosecutors, in a domestic violence case, without the prosecutor's consent. And we'll put you in the program and see how you do if you complete the domestic violence class successfully, and otherwise complete the probation. I'm sure the prosecutor would agree to a deferral. If you don't, then this will show on your permanent record. I'm going to leave the no contact provision in place until further order. I have 2 options: lift it and have her request me to put it back, or leave it in place and have her request me to lift it. But I don't want to lift it without input from the complainant. No contact remains in effect until further order of court. You are communicating between intermediaries, and that's good. You guys have done about as best as you could through the holidays. But she's never returned any contact from the prosecutor's office. And I would ask whoever your intermediaries are to direct her to contact the victim advocates at the prosecutor's office or the probation department, and I can determine what to do with this. If you don't have any, or you're not married, and you don't have a custody or support order, who's paying all the bills?
Just when I have the kids, it's on me, that type of deal.
Well, who's paying the electric bill, the gas bill at the address?
I'm not sure what she's doing. Last I knew, she was trying to move out of there. So, I mean, I do know that she's a couple months behind on the rent. Because when I was there, I took care of a lot of that.
Well, so now that you're not there, you don't have to pay rent anymore.
Well,
that's a good deal.
I pay my dad, but correct.
And your 2 kids are a half a step from homeless. So you don't know who's paying the propane bill or the electric bill?
I do. I would assume she is.
Well, what does she have for income?
She is a server at Judd's Barbecue in Angola.
Who watches the kids while she's at work?
Right now, with all this going on, I'm off during the week because my work didn't want to put me on all of my hours. My mom takes them quite a bit, and my dad also watches them.
She got a 4-month-old baby and she's working as a server in a 45 minutes away?
Yeah, she works 5 or 6 days a week. I mean, she makes okay money. But like I said, I wouldn't know for sure what her financial situation is exactly.
What do we need a probation here? Yeah, it's like I'm dealing with two 18-year-olds. All right, I'd like to hear from her. All right, you're on probation on the domestic violence charge. No drugs, no alcohol. Test as directed. No assaultive or threatening behavior. They could also use some substance abuse counseling. I'd like you to stay plugged into AA. No contact remains in effect unless I hear from her, in which case I can lift it. At least you can talk to each other. Whether you're gonna move in together, I don't know, but and you're lucky you didn't hit a tree or something. In the meantime, this does not affect your driving privileges, even though you were driving around 3 times drunk. I want you to go down to the probation department and get plugged into that. I will say your attitude has been pretty good. As Ross said at the time of the plea back in December, you're like, okay, I owned it. I accept responsibility. I don't like you punching her in the face. I don't like you going over there in direct violation of my orders. But let's see if we can make something out of nothing here. Otherwise, you'll end up in jail for a while, 80 days. All right, you go down to probation. I will reserve on the deferral question.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Ms. Scott. It's downstairs, I should.
Mr. Herrick here.